to the session on comparative constitutional law from US and Indian perspectives. Today, we have with us two eminent scholars of comparative constitutional law, Professor Dr. Dilip Ukey and Professor Sital Kalantry. I request our Dean and Director, Professor Dr. Purvi Pokhriyal, to kindly welcome our speakers.
Thank you, Sukrit. Good evening, friends. We are indeed honored to have with us two distinguished scholars on constitutional law, Professor Sital Kalantry and Professor Dilip Ukey. Both are renowned scholars when it comes to the constitutional law discourse. When we teach and when we talk about India and US, one being the largest democracy of the world and the other being the oldest democracy of the world, we have so many synergies and we have so many lessons to learn from each other. And with these idea in mind, we thought to have these comparative constitutional law sessions. And Professor Sital was kind enough to accept our invite. And thanks to Professor Ukey also, who has readily agreed to be with us on this panel. Professor Sital would share the perspective with reference to the US Constitution, and Professor Ukey would be complementing with the Indian perspective on this subject matter. I'm sure that session is going to be very enriching and insightful for all the students. On behalf of the students and the Nirma University faculty and friends, welcome both the distinguished speakers. Thank you, Sital. Thank you, Professor Ukey.
Thank you, ma'am. Before we begin with the session, let me please introduce our speakers. We have with us Professor Sital Kalantry. She is the clinical professor of law at Cornell Law School, New York. She writes in the fields of comparative feminist legal theory, international human rights, and empirical studies of courts. We are also graced by the presence of Professor Dr. Dilip Ukey. Sir is the Vice Chancellor of Maharashtra National Law University, Mumbai. Sir writes in the fields of constitutional law, jurisprudence, and human rights. Further, I would request all participants to keep their mic on mute and to send in all their queries directly to me through the chat box. Now, I invite Professor Kalantry to please deliver her lecture. Please, ma'am.
Thank you, Professor Garg, and thank you so much to Dean and Director Dr. Purvi Pokhriyal for inviting me here. I'm grateful to Vice Chancellor Ukey for his comments and his engagement. And good evening to all NIRMA students, professors, other guests, advocates. I'm excited to be here today with you. So, as was mentioned, my talk will be about comparative constitutionalism, focusing on India and the United States. Specifically, I will talk about what we can learn about the institutional design of the United States Supreme Court from the design and functioning of the Indian Supreme Court. There is a bill pending in the United States to change the tenure of US Supreme Court justices from life tenure to 18-year term limits. I will draw upon the experience of the Indian Supreme Court that have short tenure for judges and early retirement ages to caution against a proposal of term limits in the US. So before I do that, let me talk a little bit about what comparative constitutional law is and why we study it. So it's a subdiscipline within comparative law. Well, comparative law looks more broadly at private law, such as comparing contract law across jurisdictions. Comparative constitutional law focuses on constitutions, as the name suggests. But some people have argued that it's really hard to compare public law because constitutions are constructed and function in extraordinarily different contexts. They vary in democratic institutions, political and historical contexts. I argue that the comparison is possible, but it really requires deep and extensive knowledge of both countries that are being studied. So next, I want to discuss what do we gain from this. So many constitutions have similar provisions because they have borrowed from one another. So one country might learn something about how another court has interpreted that similar provision. Second, even when provisions are interpreted differently, I think it's helpful for democracies to see how other countries have balanced various rights against the different stakeholders. And finally, I think even when contexts are different, that can still be helpful because the courts can distinguish those contexts. Comparative constitutional law has grown over the last several decades because there's been a proliferation of constitutions around the world. The UN human rights treaties have tried to create a universal understanding of human rights. There's the development of transnational courts like the European Court of Human Rights and the Inter-American Court of Human Rights, which interpret provisions similar to what are in many contracts. And there's increasing association between judges and scholars. Right, so constitutionalism is different than what a constitution is. A constitution is a written document. It's a blueprint for society, right? It explains relationship between the center and the state and people's rights. It also has some popular resonance, as we saw that people banded again under the common idea of the equality under the Constitution around the protests for the Citizenship Amendment Act. In the United States, the Constitution drew into the conversation when there were riots or insurrection in Capitol Hill, where some people tried to take over our government. So constitutional means governance by popular sovereignty. The law, the Constitution is a supreme law of the land. It's representative of democracy. This semester, I'm teaching a class on comparative constitutional law, focusing on India and the United States. While many law schools have classes on comparative constitutionalism, they don't really focus on India. They focus on other countries. And I think this may be the only class that focuses on that. I believe that India has not gained enough prominence in the United States Legal Academy, given how accessible its legal culture is to America, because of the similarities in language and democratic traditions and the common law heritage. Each country has a Supreme Court that has protected the rights of people in the face of authoritarian. So mandatory term limits appeal to liberals who have wanted Justice Ginsburg to retire while a Democrat was president. But arguments for term limits find support not only among liberals, but also conservatives. A bill was introduced in the House of Representatives that would create a term of staggered 18 years, with every president eventually having the ability to appoint 2 justices for every term that he or she is in office. Legal scholars have argued that the 18-year staggered terms at the US Supreme Court will increase democratic accountability because each president would then be able to appoint at least 2 justices. It will decrease politicization of the appointment process, where currently there are so few slots that open up. Since judges stay for such a long time, it's hotly contested at the Senate. And it would also ensure that judges who are no longer mentally capable do not remain on the bench for long periods of time. If this proposal were accepted, then there would be several consequences. First, judges would spend less time on the court than they do now. Second, the staggered terms would mean that the same judges would not sit together for long periods of time as they do now. Third, the Chief Justice of the US Supreme Court would be in his role for a shorter period of time. At least 18 years is the maximum. Fourth, judges are likely to leave their positions when they're much younger than when they retire now. Presidents are not likely to appoint judges that are too old for fear that they might die in office, and when they die, their successor might be appointed by somebody from the other political party. So this would mean that judges, when they do retire, have a long life and earning capacity in the private sector after they retire. But right now, the way the court functions in the U.S., in the past 6 justices to leave the US court, 3 have died in office: Ginsburg, Rehnquist, and Scalia, and the other 3 retired at approximately 83 years of age. So though there are many differences in institutional design, political context, and democratic traditions between India and the United States, I still think the experience of the Indian Supreme Court, where judges spend a relatively short period of time, can be relevant to the US. In India, as you know, the retirement age is 60, but over time, they've been the age of appointment has increased. So on average, they're appointed when they're 60, and they spend maybe 5 or 6 years on the court. Everyone here would have a lot of knowledge, and I welcome your thoughts and feedback on that. So when the Federal Court of India was conceived in 1937, life expectancy was around 30 years. But recent data shows that life expectancy at birth is 65 years for the poorest fifth households in India and 72 years for the richest fifth households. So with life expectancy increasing, judges now have more time in their lives post-retirement than they did in the early days of the court. When judges retire at a relatively young age, they're more likely to need to seek post-retirement jobs. In addition, perhaps wanting to occupy themselves with productive work, judges also need to supplement their pension to maintain their lifestyles. A Supreme Court judge's salary in Delhi, they maintain almost half their salary after they retire, not a full salary. Thus, the post-retirement benefits don't necessarily match the salary when the judge was in office. But the Indian Constitution prohibits a judge from doing one of the most lucrative things, which is return to private practice. He or she is not able to do that. This, as many of you are aware, this is not news to many of you, this creates incentives to pander to the most likely to give them government jobs, and these are government actors. A significant number of judges do in fact take government jobs post-retirement. Although there was great uproar when Justice Gogoi accepted a job offered by the government in the Rajya Sabha, it is becoming common for retired judges to work in post-government jobs due to there being more specialized tribunals and public commissions. Though of course, judges also take jobs as arbitrators. So when a judge accepts a post-retirement job, there's a perception of that there might be some pandering. And this was even raised as a concern in the Indian Supreme Court when in the Constituent Assembly, one of the drafters said they wanted the judges to be prohibited from taking jobs by the government. Of course, that didn't happen. An empirical study based on a data set of cases of the Indian Supreme Court by professors in the University of Singapore, Madhav Ani and his colleagues, actually thought that there is pandering behavior in the Supreme Court. They looked at the behavior of judges who retired close to an election and compared it to the behavior of judges who retired when an election was farther away. The study finds that judges are more likely to issue pro-government decisions when there is not likely to be immediate government, when there is not likely to be government turnover immediately after retirement. In other words, their data shows that they're more likely to issue pro-government decisions when there's less risk that the government might turn over in an election for a period of time. So if they're farther away from an election, they think, well, it's going to be the same government in place, so their decisions tend to be more pro-government. Alternatively, when Supreme Court judges are less likely to rule in favor of the government when retirement is closer to an election. The study also found the effect was greater in important cases. They determined that if a case was based on whether an attorney or solicitor was listed on the case and the number of senior advocates. Most remarkably, they found that judges who author favorable judgments in important cases are likely, in fact, to receive prestigious government jobs. This suggests that an early retirement age has created incentives for decisions in favor of the government. And of course, judges should only weigh the merits of the cases in both parties rather than be motivated by those incentives. Another consequence of the early retirement age in the Indian Supreme Court is that judges spend a relatively short time on the court for two reasons. The appointment age is increased over time and the retirement age is fixed. Post-collegium, the appointment age rose to about 60 years. So compounded by the fact that there are benches of two, where one bench can issue a decision that's very contrary to another bench. And this has occurred in different cases. For example, a death penalty case was supported by Justice Basiat for a serious crime as rape, but then another Justice, Sinha, sitting judge, decided that no, there shouldn't be a death penalty in almost any case. So this kind of conflicting jurisprudence, and it's possibly because they retire early, they don't spend enough time on the court, possibly also because of the two benches, creates confusion amongst the lower courts as to what precedent to follow. Some scholars have also found that the Supreme Court cites Scholars of the Supreme Court have found that the Indian Supreme Court cites very few precedent in many of its cases. This may be because of lack of time, or because they just. So to just explain then what the relevance of the Indian Supreme Court design is to the U.S. proposal is, I think that what we can learn in the U.S. from what's happening in India with the short tenures of judges is that it could be possible that when U.S. Supreme Court judges retire at an early age, when they're term limited, there is the possibility of pandering to potential employers. Here in the US, they would be able to there is no ban on private sector work, so they could get lucrative jobs at appellate law firms if they leave the court at such an early age. And even if they're provided a pension, that pension would never match what they got from the law firms. There's also the possibility of doctrinal instability. When judges are constantly changing, when they're not on the court with each other for a long period of time, then the precedents can change. One empirical study had found that if the 18-year proposal was in effect from 1973, one of our most important cases, Roe v. Wade, would have changed tens of times. So here you have, abortion being allowed and not allowed and not allowed when you have many different, when you have a short term limits for judges. The institutional stability would be a bit less because in the US, the Chief Justice doesn't have much power as the Indian Chief Justice does, but I think there still would be instability as the Chief Justice does have power over the institution, over maintaining other things. So just to conclude, I think there's a need for increasing comparative study of the Indian and the US constitutions. Historically, scholars have only looked at the US law to see how it can benefit Indian law and legal institutions. But as Barbara Crossman has noted, it's time to turn the gaze back to the United States. And in this paper, I've shown how United States legal institutions and proposals on term limits, what they can learn from the Indian Supreme Court constitution and experiences.
Thank you so much, Dilip. To Professor Ukey to please give his lecture.
Thank you, Professor Garg. Professor Sital Kalantry, Professor Puri Pokhariyal, Director and Dean, Nirma Institute of Law, all other participants and dear student friends. It is indeed a great pleasure to listen to Professor Kalantry and her views about US Supreme Court and judges and their tenure and appointment as. Of course, when we talk about comparative constitutional law, of course, there are several diverse things which are there. Firstly, I would like to briefly comment upon the appointment of judges, moreover, the appointment of Chief Justices here in the Indian Supreme Court. And then two or three areas I would refer to from India and US Constitution to demonstrate that how it has been applied here in India. As we know that, and Professor Kalantry has pointed out, Indian Constitution came into force on 26th January 1950. So far as appointment of judges is concerned and their tenure of particularly the Supreme Court judges is concerned, as we know, Article 124 of the Indian Constitution, which provides for the appointment of Chief Justice and other Supreme Court judges. However, there is no such mention or provision that who shall be the Chief Justice of India. In view of this, the tradition or convention was developed right from the commencement of the Constitution, that rather till 1958 Supreme Court had functioned. It did not have its own building as it is there today. It functioned from the Parliament itself. Now today's Central Hall, it was the Supreme Court of India then, Independent Supreme Court of India then. It was only in 1958 Supreme Court moved it in its own building, own structure. So in view of the absence of any such provision that who shall be the Chief Justice, the convention was developed right from the Pandit Jawaharlal Nehru's first Prime Minister, that whosoever is the senior most amongst the Supreme Court judges, senior most not by age but senior most by way of the seniority of tenure, shall be appointed as the Chief Justice of India. As we know that 1973, the landmark judgment was delivered by the Supreme Court in Keshwananda Bharati, wherein the doctrine of basic structure was evolved by the Supreme Court, and that judgment was delivered by the largest ever bench of 13 judges. The majority was divided 7 versus 6. And thereafter, rather the new Chief Justice was to be appointed, wherein senior judges Justice Shalad, Justice Grover and Justice Hegde, not 1, 2, 3, but rather 3 senior judges were ignored, were overlooked. Because as you know, the judgment which was delivered by the Supreme Court then, that Parliament can amend Constitution, Parliament can amend fundamental rights, but it cannot amend the basic structure, basic features. That was the judgment delivered by the Indian Supreme Court in Keshwananda Bharati. Whereas previous to that, prior to that, it was in Golaknath, wherein the Indian Supreme Court said that that was the 11 judges bench. Parliament has an unlimited amending power as such. So it was a freedom, absolute freedom for the Supreme Court then, absolute freedom to the Parliament then. So Keshwananda has placed certain limitations by way of basic features or basic structure doctrine, that limited amending power itself was one of the basic feature, was one of the basic structure. Parliament doesn't have an absolute power to amend the Constitution, which was not liked by the then Prime Minister, Mrs. Indira Gandhi. And then, when the appointment of the new Chief Justice was to be decided, not one till right from 1950 till 1973, that convention or constitutional convention or practice, whatever we may call, was observed, was followed, that senior most judge of the Supreme Court was appointed till then as a Chief Justice of India. However, herein, after the judgment delivered by the Supreme Court in Keshwananda Bharati, Justice Shalad, Justice Grover and Justice Hegde, 3 senior judges were overlooked, were ignored, and the 4th one, who was on the other side, Justice A.N. Ray, was appointed as the Chief Justice of India. The 4th in seniority list was appointed as Chief Justice of India. Why? Because it was Justice Ray who held that Parliament has an absolute amending power of the Constitution. So that was liked by the then dispensation, political dispensation, that he is the one who has given absolute power to the Parliament to amend the Constitution, and therefore he was appointed as the Chief Justice of India. As we know that in India, Supreme Court judges or the Chief Justice of India, Chief Justice of Supreme Court of India, they can serve only up to the age of 65 years, whereas High Court judges can serve up to only 62 years, a fixed tenure. Wherein, when Chief Justice Ray was appointed as the Chief Justice of India, of course, those 3 senior judges, as I said, Justice Shalad, Justice Grover and Justice Hegde, they had resigned from their post in protest. Because the Constitutional Convention, which was developed till then, right from Pandit Jawaharlal Nehru, the first Prime Minister, was ignored, was diluted, was destroyed rather. And when thereafter the matter came, national emergency was imposed in 1975, precisely on 25th June of 1975. And Mrs. Indira Gandhi's election to the Lok Sabha from Raebareli constituency was declared as null and void by the Allahabad High Court. And then appeal was filed by her in the Supreme Court. In between, the 39 Constitutional Amendment Act was passed. By virtue of that, by 39 Constitutional Amendment Act, Article 329A was inserted into the Constitution, which provided that any pending matter or pending appeal in any court of law in relation to the election of the Prime Minister shall be null and void. That was the Constitutional Amendment. So appeal filed by Mrs. Gandhi against the judgment of Allahabad High Court and the Constitutional Amendment, 39 Constitutional Amendment Act, both were challenged and both were clubbed together in Indira Nehru Gandhi versus Rajanarayan. Wherein same Chief Justice A.N. Ray was appointed by none other than Mrs. Indira Gandhi, who headed the bench herein. See, 1973 to 1975, hardly 2 years difference or so. When the matter came up before the bench, headed by the Chief Justice A.N. Ray, he declared the 39 Constitutional Amendment Act as an unconstitutional on the basis of basic structure doctrine. Free and fair elections as a matter of basic feature. Judicial review as a matter of basic feature. Secularism was a matter of basic feature. In that sense, the person just 2.5 years before or so held that Parliament has an unlimited absolute amending power, has changed its view and placed the limitations upon the amending power of the Parliament, amending power of the Constitution of the Parliament. That has nothing but the facet of, we would say, either the Keshavananda Bharati or Indira Nehru Gandhi or the doctrine of basic feature is itself nothing but is the facet of the notion of constitutionalism. I do not wish to go in detail of all those things. And since then, the journey of doctrine of basic features started. We know that the amending US Constitution is not only difficult, it was really sometime impossible because it is a rigid one, whereas the Indian Constitution adheres to blend of rigidity and flexibility, wherein few provisions could be amended by way of simple majority, few provisions could be amended by 2/3 majority, and few provisions could be amended by 2/3 majority plus consent of 50% of the state. And that's what rather the difference between either in case of appointment of judges of US Supreme Court or the Chief Justice and the appointment of judges here in India of the Supreme Court of India. Of course, then the judges transfer case SP Gupta onward till the recent one, NJSC. Including the master of roster thing, who is to be the master of roster? Is the Chief Justice of India. That in case of such situation, that who shall have the primacy? So Supreme Court Advocates on Record Association, Sarojini Ramaswamy against Supreme Court of Advocates on Record Association, and then NJSC judgment wherein the bill was adopted. It was passed by the Parliament to create the commission, National Judicial Appointment Commission of Judges, including the inquiry, that was struck down by the Supreme Court itself and restored its primacy, the collegium, which was evolved by the Supreme Court. Judges appoint judges. That's what rather, in case of the Supreme Court and High Courts, is the procedure and the practice is here. Right or wrong, that apart us. What I would like to draw here in the kind of the comparison between the US Constitution and Indian Constitution is, as all of us know well, that India has borrowed the notion of fundamental rights from the US Constitution. Of course, in US Constitution itself, right from its inception, those rights were not there. They were inserted by way of amendments. So very first amendment, that is about the freedom of speech and expression, I believe. It provides the fundamental right of freedom of speech and press therein. However, there are no limitations or no restrictions provided for. All those grounds to impose the limitations or restrictions upon the freedom of speech and press therein, they were evolved by the Supreme Court by way of its judgment, by way of its decisions. Whereas either the famous Sullivan's case, still you could recall. Whereas here in India, as we know and well aware that it is not only freedom of speech, but expression, which includes even press. So firstly, the freedom of speech and expression is wider than what the freedom is guaranteed there or provided there in US Constitution. That is one. Because expression has a wider connotation, is a wider concept, broader concept. Secondly, Article 19, Clause 2 provides for the grounds to impose the limitations which are to be reasonable limitations. Clause 2 provides for 7-8 grounds: sovereignty, security of the state, decency, morality, public order, contempt of court, defamation, so on and so forth. Such grounds are not there inbuilt in the First Amendment of US Constitution. So that is one kind of a difference. Though India has borrowed, Indian Constitution, it has borrowed, yet there is certain difference, there were certain modifications with which we are all aware. Most importantly, the Doctrine of Judicial Review, which was laid down by Chief Justice Marshall of the United States Supreme Court in Marbury versus Madison in 1803, a landmark judgment which was delivered by Chief Justice Marshall there in Marbury versus Madison, which has evolved the Doctrine of Judicial Review. That any congressional legislation, if it takes away any of the basic right or fundamental right, Supreme Court has a power, US Supreme Court has a power to declare such congressional legislation as an unconstitutional one. That doctrine has been borrowed by Indian Constitution, by Indian Supreme Court. And that's what rather the Keshwananda Bharati and all other cases, all other decisions, they are the product of judicial review. Of course, that power is inherently there, positively, expressly, in a written way there, provided under the Indian Constitution. Either Article 13 itself, Article 13, as we say, is the facet of doctrine of judicial review. It says that states shall not make any such law which takes away or violates or abridge any of the basic rights or fundamental rights. That is one. Wherein particularly Article 21 and Fifth Amendment of the US Constitution. The Fifth Amendment of US Constitution as it goes and as it is there, and I believe that still it is so, that Fifth Amendment of US Constitution provides that no person shall be deprived from his right to life, liberty, and estate without due process of law. Though it has been borrowed, that was rather the John Locke's view. Rather, Lockean theory has been incorporated in the US Constitution by way of Fifth Amendment. It was a positivization of natural law by way of Fifth Amendment in the US Constitution. Whereas under Article 21, when it was being drafted, it was Article 19 then under the draft Constitution. Then advisor Sir B.N. Rao visited US and met then Justice Felix Frankfurter, who advised him rather in a most elated manner. Sir B.N. Rao pointed out to Justice Felix Frankfurter that we are going to borrow your Fifth Amendment in its entirety in our Constitution. Justice Felix Frankfurter advised Mr. B.N. Rao that if you borrow our Fifth Amendment as it is, that will give the widest possible judicial discretion to the judges, to the Supreme Court judges particularly. Hence, my advice is that because the word due, it is not subject to defined crystal clear definition or parameters. That's why it is my advice that you don't borrow this, don't incorporate this. And suppose a judge decides a matter in an arbitrary manner, then what? And that's why. Rather, I must mention at this juncture, in the draft Article 19, today's Article 21, the word due was very much there under the draft Indian Constitution, under the draft Article 19 of Indian Constitution, relating to right to life and liberty. And that's why. The word which was there, the word due which was there, very much there under the draft Constitution, when Sir B.N. Rao returned, discussed that matter, debated that matter, deliberated along with the Constituent Assembly, particularly the drafting committee, and then the word which was there due was deleted. And that's why when it was renumbered as Article 21, it came like no person shall be deprived from his right to life, liberty, without, except according to procedure established by law. However, in the first decision itself came up before the Supreme Court in Gopalan, it was contended that the word procedure established by law provided under Article 21 is equivalent to, similar to the word due process of law of the Fifth Amendment of US Constitution. Then the Supreme Court judges in A.K. Gopalan versus Madras held that the word due which was there under the draft Constitution, which was deleted subsequently, how we can read the same word under Article 21. To our mind, they said, to our mind, to us, procedure established by law is nothing but whatever the procedure prescribed by law, that's all. Whether that procedure is just, reasonable, and fair or not, we have nothing to do with this. We look into only these two. Is there a law? If yes, does that law provide the procedure? Yes. And thirdly, what are the procedure which has been prescribed by that law, whether it has been observed, that's all. Nothing beyond it. Neither will look at whether that law is just, reasonable, and fair, nor will look at whether that procedure is just, reasonable, and fair. It was only Justice Fazal Ali who delivered the dissenting judgment in Gopalan, who held that Article 21 and particularly the procedure established by law is similar to, is equivalent to the due process of law as provided under the Fifth Amendment of the US Constitution. However, as we know that majority prevails, and that's why majority prevailed. However, as all of us are aware, that the same matter came up before the Supreme Court in Maneka Gandhi versus Union of India in 1978. Whatever was rejected by the Supreme Court in Gopalan was upheld by the Supreme Court in Maneka Gandhi. Same contentions which were advanced, same contentions which were argued, that procedure established by law provided under Article 21 of the Indian Constitution is similar to, equivalent to the Fifth Amendment of US Constitution, that is due process of law, which was upheld by the Supreme Court. Justice Bhagwati, Justice Krishna Iyer, great judges then, pioneers then. This was, Maneka Gandhi was nothing but the facet of constitutionalism, because it has placed certain limitations upon the exercise of legislative as well as the executive powers of the state. That's why it has assumed the significance. So in that sense, the Fifth Amendment was impliedly, I would say, impliedly borrowed, impliedly applied. And since then, it is being applied by the Supreme Court subsequently till now as such. When we look at either the Keshwananda Bharti and post-Keshwananda Bharti cases, or the appointment of judges cases, I do not wish to go at length in all the matters, or the decisions delivered in relation to Article 21, particularly the procedure established by law. All these are the instances of the doctrine of judicial review, which has been strengthened. All these are the by and large instances of constitutionalism, which has placed limitations not upon the exercise of legislative power of the state, but also upon the exercise of executive power of the state. Particularly in relation to doctrine of basic structure or doctrine of basic feature. Keshwananda till now, either it was Ismail Farooqui or S.R. Bommai, so on and so forth. There are several such instances wherein Professor Upendra Bakshi went on to comment that otherwise, we say when we study Indian Constitution that one of the basic principle, not the feature, one of the basic principle of Indian Constitution is the supremacy of the Constitution. It is the Constitution which is supreme. Unlike earlier Great Britain, wherein the Parliament was supreme, as we know that parliamentary sovereignty or parliamentary supremacy has prevailed there. However, looking at all these instances, either the decision delivered by the Supreme Court, Indian Supreme Court, in relation to amending power of the Parliament or appointment of judges or right to life and personal liberty, so on and so forth. There are various diverse areas. Even in case of the determination of the age of a High Court judge, Article 217, Clause 3 provides expressly, it was held so in J.P. Mittal, provides expressly that the decision of the President to determine the age of the Supreme Court judge is final. Ouster clause. Judicial review was excluded expressly. However, in J.P. Mittal, the Supreme Court held that even though Article 217, Clause 3 provides that decision of the President to determine the age of a High Court judge is final. However, if it is found that the President of India has exercised its power in an arbitrary manner, in an unreasonable manner or irrational manner, or without any justification or grounds or material, then despite of such finality accorded to his decision by Clause 3 of Article 217, such decision could be declared as unconstitutional, illegal, invalid. And that's what rather it has emboldened the notion of judicial review. It is nothing but, I would say, the facet of constitutionalism, even J.P. Mittal. It was 1967, the judgment was decided by the Supreme Court in J.P. Mittal. And that's why. Let me revert back to the amendments thing. That Professor Bakshi commented that, though that's what I was about to say, I was saying that it is the supremacy of the Constitution is one of the basic principles of Indian Constitution. However, Professor Bakshi said, supremacy of the Constitution has been substituted and lodged with the supremacy of the Supreme Court. Because what is supreme is to be decided by the Supreme Court itself. Whether this particular feature is a basic feature or not, it is nowhere mentioned, provided all of us are well aware under the Indian Constitution. It is for the Supreme Court, it is for those judges to declare that this is the basic feature as such. And that's why he made a comment, he made an observation that the supremacy of the Constitution has been lodged and substituted with the supremacy of the Supreme Court as such. And that's why. No doubt, we have borrowed several things from the US Constitution, like Doctrine of Judicial Review, as I said, which was evolved by Chief Justice Marshall in Marbury vs. Madison, and all other things. Nevertheless, rather, one more instance I would like to point out about the Doctrine of Prospective Overruling. Doctrine of Prospective Overruling, which was evolved by the Supreme Court in Great Southern Railway Company, wherein Doctrine of Prospective Overruling, in a sense that the decision is to be applied not from the past, from the date of the cause of action, but rather it is to be applied from the future. Great Sunburst Oil Company. The judgment was delivered by the US Supreme Court. Therefrom, we have borrowed that in Golaknath. Indian Supreme Court borrowed that doctrine in Golaknath, doctrine of prospective ruling. However, though it was borrowed, but not in its entirety, but with certain modifications. Whereas the law declared by the Supreme Court herein otherwise comes into effect from the date of cause of action. However, if the US Supreme Court doctrine was to be applied, the prospective ruling would have been applied here in India from the date of the decision. Nevertheless, taking into account the peculiar circumstances involved therein, in Golaknath, Supreme Court decided that whatever the amendments made, as we know that Golaknath it was held, that Parliament doesn't have the power to amend the Constitution, to amend fundamental rights. However, hereafter, while applying the doctrine of prospective ruling, borrowing from the Great Sunburst Oil case, decision delivered by the US Supreme Court, that all those amendments carried out by the Parliament were to remain valid forever. Only thing is that from the date on which the Golaknath was decided, the Parliament was not supposed to exercise its amending power in relation to the fundamental rights. So even though doctrine was imported, doctrine was borrowed on Sunburst Oil Company's case from the US, decided by the US Supreme Court, however, it was applied with certain modifications as such. Of course, there are several such things when we talk about comparative constitutional law. As I said, that this is an ocean, or rather I would say number of oceans. So we need to confine ourselves to some way, and that's what rather I really compliment my colleague Dr. Puri Pokharial, and it was really great pleasure to listen to Professor Kalantry, Sital Kalantry, and all others. I thank you for giving this opportunity to share a few thoughts with you. Thank you so much.
Thank you so much, sir. We have a few questions. One question is for Professor Kalantry. This is, as sir has talked about a lot of judgments where we have cited in India, we have cited a lot of Supreme Court judgments. We have used US Supreme Court judgments and judgments from the United States to develop doctrines in this country. Just how far can we reverse this trend, and whether can we see this trend, as you talked about this reverse legal transplants, at least can we see this trend where the US is borrowing something through its Supreme Court, through its judgments from Indian jurisdiction?
Yes, that's a great question. So the Indian Supreme Court over time has initially, in the early time period, it was citing more to UK cases, as you would expect. As it's developing its own jurisprudence, it's learning from how the UK has interpreted it. But over time, it's interesting to note that the Indian Supreme Court is in fact now citing more to US cases than it previously was. In fact, I have a slide that I can show on this if I can share my screen, which I think is kind of interesting. Here you can see US Supreme Court citations. This is not so interesting. This other piece is interesting here. Look, the Indian Supreme Court citations to US law has increased over time and English law has decreased over time. And then this is sort of overall citations. But to answer your question, what's really interesting about this is if you look at table 6, this table shows when the US Supreme Court borrows from other countries. And in table 6, you'll see the India, and these are only in constitutional cases, right? So the US Supreme Court doesn't use foreign precedent that much. And when they use it, there's so many objections. When Breyer used it in Kennedy used it in Lawrence and Roper, there was calls to impeach him. Why are you looking at other countries? We need to focus on our own country. So of the limited opinions, this one study done by political scientist David Simon found that they cite Canada the most, Australia, France, and look at that, they actually cite India. I mean, you might think 3 is very little, but there's no other, all these countries are first world developed industrialized countries, right, that they're citing. So India is the only country that one could say falls within in a different economic status that they cite. So I do think that there is some interest in India, as you can tell from this empirical overview. Not enough. I think there should be more interest and there should be more citations. So that's kind of my response. I also have one brief comment to make to what Professor Ukey had said, is just to point out a difference in the amendment process. So India is where the Indian Constitution is relatively easy to amend, right? Parliament with 2/3 can amend it, whereas the US Constitution requires 2/3 of both of our houses, and it requires 3/4 of the states to amend, which means that it's been very few amendments. There's only 27 amendments over time, whereas India has 100 amendments. And this could also, there's different costs and benefits of this, right? The benefit is it means that people who are currently ruling have the ability to make changes, but then also means that you have the risk of things like happening if people don't agree with what happened with Kashmir, right? That was all done through a constitutional amendment by one party because it was so easy, but it, where the semi-autonomous status was changed. And in the US also, India has the basic structure doctrine, but it's because the amendment process is so easy. What the Indian Supreme Court has said is that they can review unconstitutional, they can determine whether an amendment is unconstitutional. Whereas the US Supreme Court doesn't have that power right now. The US Supreme Court has the power to only review legislation as against the Constitution, but it can't review an amendment as against the Constitution. It could come up with that doctrine if, let's say, the Trump administration said, we're going to, and everyone of the states agreed, there'll be no more elections. What can the Supreme Court of the US do? It doesn't have the same power yet as India.
Just a follow-up question to that. So because whenever this idea of citing foreign judgments crops up about the United States, often the name of Antonin Scalia is mentioned. So just to ask from that perspective, then how many Scalias are there then in the United States? So are we not trying to refer foreign judgments because of what Scalia has said, or is that a belief that is ingrained in the mind of the judges themselves?
So there's quite a bit of a debate as to why you should cite to foreign judgments. There have been 3 theories that is proposed, and Professor Chaudhry, who was a former dean of Berkeley Law School, has talked about different theories. One is, and different people use different theories, is the Universalist theory. Well, we should cite foreign judgments because we all have a common notion of rights and equality, and it's appropriate to look at India because India is trying to do the same thing. Right. The other view is more the Scalia view, which is the particularist views, which is that each country is so different from each other. Right. In India, you have the parliamentary system. In the US, you have a different kind of democratic system. You have different traditions. You have different languages. You have different ways in which political movements interpret it. So if I just look at India's, if, for example, when in the Nas Foundation judgment, when 377 in the Delhi High Court, looked at the right to privacy and just cited Roe v. Wade, you really need to understand where Roe v. Wade came from, why it was necessary in India. It might not be the same reasons that in the US as it is in India. So that's what Scalia, one of his arguments is. And also Scalia says, well, how can we use it as persuasive authority in one case and not in others? Why do we only cite it when we want to declare same-sex homosexual conduct illegal? Then we'll cite the European Court of Human Rights. But when we want to keep abortion legal, we're not going to cite to Latin America, where most Latin American countries predominantly it's against their constitution. So I can't answer how many Scalias there are. I can answer that there's a debate between sort of conservatives and liberals, and often it's dispositive, right, of the outcome, where conservatives don't want certain outcomes, liberals do want certain outcomes, and then conservatives like Scalia say there's no principle, right? What's your principle of when you use it? And we still need to develop that principle.
Thank you, ma'am. There's a question for Professor Dr. Dilip Ukey. It is, though conversations about setting up appellate court and separate constitutional bench of Supreme Court have happened, we have not been able to achieve that till date. What could be the reasons behind the same?
Reasons, we can't ascertain those reasons. Reasons may be political reasons also. Reasons may be the policy, because these are the policy decisions. But yes, as a matter of convenience, one shall look at the convenience. Because when we say that access to justice, so where is the access to justice? From Kanyakumari to reach to Delhi, So that's what rather, either 4 benches somewhere, east, west, north. North already it is there, south. So reasons, unless and until are shared with us, because that document is not the public document, so it is really difficult to comment upon that. But yes, it is true that convenience matters more.
Thank you so much, sir. So those were the questions that we had with this from the student side from the session. Thank you so much, sir, and thank you so much, ma'am, for sharing your views and your ideas with us. Also, I would like to extend a thanks from the side of Institute of Law, Nirma University, for accepting our invitation, for bearing through the troubles that we had during this session, and for still delivering the lecture and for interacting with us during these troublesome times. Thank you so much.
Thank you.
Thank you. Nice meeting.
Nice meeting.
Thank you, sir.